Thank you. Understanding the requirements and the timeline for import or regulatory planning requires discipline to avoid disappointment. Key elements to consider include, first of all, failure to allow sufficient time for the process. Importing products into the U.S. for evaluation or sales can require as many as a dozen different documents to assure compliance with regulations of 4 or more government regulatory agencies. In some cases, additional approval is required by every state in which the product is intended to be tested. Complete preparation, submission, and approval of the necessary import documents usually requires a minimum of 8 weeks. The most common enforcement action reported on EPA's website is failure to file the necessary paperwork for import prior to arrival at the port of entry. Filing documents after the shipment arrives may not be viewed as a serious violation to us, but this can result in extreme fines, especially if the agency investigates and finds multiple instances of the same violation. For both regulatory planning and product import planning, a key point is the phrase does not require EPA registration. You must remember this does not mean unregulated. Fertilizers are highly regulated by each U.S. state, although they do not require federal EPA registration. Inoculants are defined differently in each state and are considered totally unregulated by EPA. They do not require registration federally, but many states have recently developed registration requirements for inoculants. 25B minimal risk products exempt from federal registration are required to be registered in all but 11 states. The critical product knowledge needed for approval to import samples for testing includes, first and foremost, defining the product composition. Products to be imported must be defined in specific detail. In most countries, chemical pesticides must declare the active ingredient as well as every other ingredient in the formulation. Those ingredients may be held confidential according to federal or state laws, but they must be divulged to the agencies in order to obtain import approval and registration. In the U.S., this is required by the EPA. Microbial pesticides must identify all ingredients, and microbes must be identified by strain as well as genus and species. Purity of culture and absence of potential plant or animal pathogens must also be documented. Defining the intended use. To legally import a microbial pesticide in the U.S., it is necessary to obtain an import permit from USDA as well as from EPA prior to arrival at customs. Both agencies must approve the intended experimental plan, including trial locations, responsible researchers at each location, and the area to be treated to calculate the total area to be treated in the U.S. Modifications in plans require a submission of an amended experimental plan to each of these two agencies for approval prior to proceeding. Microbial pesticides trials with imported products also require review and approval by every state in which you plan to test. Chemical pesticides for evaluation only require approval of the testing plan by EPA. Labeling, utmost important. Experimental pesticides for import must bear labels compliant with defined EPA standards. Even products that don't require EPA registration should have labels that are compliant with defined EPA standards for transportation and use for experimental purposes. Labels must be reviewed and approved by EPA before a shipment arrives at the port of entry. Labels on containers at the time of customs inspection must be identical to the labels previously approved by EPA. Minor clerical differences have actually held up shipments until you could submit revised documents. Even those agricultural products that do not require EPA registrations, such as fertilizers, mini inoculants, soil amendments, and 25B exempt products are required to bear labels compliant with EPA and state regulations. Many U.S. states do not require registration of inoculants, but most want to review the label before sales occur in their state. Production and packaging at an EPA registered establishment. Products imported for testing as pesticide or plant growth regulators, chemical or biological, must be produced and packaged in an EPA approved establishment. The EPA establishment number must appear on the label submitted to EPA as well as the import documents. To obtain an EPA establishment number, if the manufacturer doesn't already have one, adds another 2 weeks to the import timeline at a minimum. And lastly, let's address very important point to me is the need for a customs broker. The best investment an importer or exporter of pesticide or agricultural production input products can make is to hire an experienced customs broker, preferably with experience in the agricultural business. If anything goes wrong, an experienced customs broker is much more likely to negotiate a resolution with customs that doesn't result in your shipment being denied entry or being shipped back at your expense. The critical knowledge needed for successful importing of samples is the same knowledge critical for an accurate projection of a regulatory pathway. Most clients want to define cost and timeline for registration before initiating a development program. Most expect a clear understanding of the cost of registration and the time required prior to investing in product testing. The truth is, this is rarely possible. Registration costs and timeline is heavily dependent on the crops targeted, the pest controlled, and the rates to be used. Defining these parameters requires multiple years of field trials to define. Any cost for timeline estimate prior to these definitions is highly speculative and seldom up to client expectations. The core knowledge necessary for meaningful discussion of regulatory requirements with EPA is a realistic projection of the label use directions to be supported by the generated data.